I just have one question for black people. What's this got to do with us? Welcome to Escaping the Echo Chamber. So Kyle Rittenhouse, if you don't know, was a young kid, 17 years old, from Antioch, Illinois, which is very close to Kenosha. Went into Kenosha, Wisconsin, to protect the community and certain businesses during the George Floyd protests / riots, however you wish to look at it. Cool. In his patrolling of the area, it turns out that he winds up shooting and killing not one, but two people, shooting a third and injuring him. And now he's on trial for murder. The left-wing media coverage is referring to him as a white supremacist. I'm like, one, how do you know that? Two, why does that matter? The three people he shot, all white people. He shot 3 white people. Yet they are referring to him as a white supremacist. Do you know why? Because they're trying to gaslight black people into becoming emotionally invested into the outcome of this trial. My first point, we cannot allow ourselves to be so easily manipulated that every time they say racism, we just react. Because he very well may be a racist. Let's say he's a racist, he's a white supremacist. That still has nothing to do with this case or us. This is white on white crime. We got nothing to do with this. What happens will happen. That's why I'm looking at the outcome of this case and I'm like, okay, I'm not particularly emotionally invested. If he gets off, he gets off. If he doesn't, he doesn't. Because just because you call him a white supremacist I'm not going to allow myself to be manipulated to get emotionally invested and to get worked up over the outcome over, like I said, what is white on white crime. That's something, this instance of white on white crime is why we got to get fathers in the homes. I'm telling you, perhaps this all could have been avoided had Kyle Rittenhouse had a father in the home. But the second point is about the greater issue, self-defense and whether or not you're allowed to defend yourself by law. Kyle is on trial and he's asserting self-defense. He's asserting that because he was chased by people, that's why he shot, he was defending himself. Now, there are people who are now saying, oh, this is crazy. In this country, what's this country coming to? You can't even defend yourself anymore. I do appreciate a point that Sonny Johnson pointed out on Fox News Primetime. This is the first time somebody has been tried while defending themselves. When it's happening to black people, when we should actually be concerned and paying attention, it will often take place in the context of somebody who isn't legally possessing a gun and who is protecting themselves against somebody else who may themselves not be legally possessing the gun and is engaged in some criminality. At that point, the issue is, why are we allowing these laws to be so skewed that black men and women are not allowed to defend ourselves? Perfect case in point is Marissa Alexander, who attempted to use a stand your ground defense against an abusive husband and was sentenced to 20 years. Fortunately, her sentence was reduced, but she should have never been convicted in the first place. You see, once again, don't fall for the smoke and mirrors that are getting us to look at the wrong issue and the wrong aspect of this case. Because like the analogy goes, what if Kyle Rittenhouse was black? What if Kyle Rittenhouse was black? Would we be upset that he was being charged for defending himself against three people coming after him? Or would we be saying, hey, this is clearly self-defense and he shouldn't be convicted and or charged? What would we be saying if he was black? Don Lemon mentioned that analogy, if he was black, and says, oh, what would we want? Do we want people just outside with guns defending their community? And I said, some of us do. Some of us realize that if we were allowed to defend our own communities, we could better make the case of why we don't need police acting as an occupying force within our communities. But the third point I want to point out is that this case is not as cut and dry as it seems. So for those on the left who think, oh, he crossed state lines, he shot 3 people, he's a murderer, I tend to think they haven't actually looked at the facts of the case. But in most cases, they are operating on very limited information. Correction, in many cases, they are operating on limited information, and they're just going by what they were told, the lies they were told by the media, and listening to the spin they were given by the media. But on the right, people are saying, okay, clearly, these guys were advancing towards him. He was running, he was retreating, and then he shot in self-defense, so clearly it's good. And I'm like, not necessarily. You see, because just because somebody is coming towards you and somebody is attacking you, whether throwing a punch, whether just coming close to you, the law doesn't necessarily say that you are allowed to defend yourself with deadly force. That's what you have to remember. It's not about what you feel is right. Remember, facts don't care about your feelings. Neither does the law. Doesn't matter if you feel that you should be allowed to shoot somebody who is coming towards you. It doesn't matter if you feel like you should be allowed to shoot and kill somebody who swings a skateboard at you. It doesn't matter if you feel like you can shoot and kill somebody who throws a plastic bag at you. It doesn't matter. It matters whether or not the law says you can use deadly force in those instances. And that's why what the law actually says is so important. That's why stuff like the jury instructions was so important. And that's why what happened on Monday with the judge throwing out the misdemeanor charge is so pivotal. Because a lot of people look at that misdemeanor charge as, oh, it's only 9 months. That doesn't really impact. But because if you look at the self-defense law in Wisconsin, self-defense is allowed to be used unless you're engaged in criminal activity. So had they found him guilty, now he wouldn't have been able to use the self-defense because, hey, he was engaged in criminal activity and that prohibits him from using self-defense. Except that there is an added feature to that law that says in the event that an individual is engaged in criminal activity and wants to assert a self-defense, then they must prove that they exhausted all avenues of avoiding the confrontation and avoiding ultimately using deadly force, or using deadly force. But of course, it still matters whether or not deadly force even applies. So a lot of people would just paint the picture, and a lot of people would just pay attention to the fact that somebody approached him aggressively. That is not enough. The law says, in Wisconsin law, it says that you must be in reasonable fear of great bodily injury or imminent death. All of these things matter in what the jury ultimately comes back, because the jury can't just go by, okay, well, he, the other guy came at him, so it was self-defense. No, they've got to look at what the law actually said. And what was also very important was Kyle's testimony itself, because what you got to realize is Kyle's testimony was more damaging to Kyle's defense than any other witness before him, which is why he shouldn't have gotten on the stand. And as somebody who's looking at things from a defendant's perspective, like, I don't know why he did. But as I saw, lawyers say, it's up to the defendant ultimately whether or not they take the stand. A defense attorney can strongly recommend that they not, but it is ultimately the defendant's decision. And in this case, from him, it's interesting that Grosskreutz, and I've mispronounced his name, said that he was pointing the gun at Kyle before Kyle shot. Kyle testified that Grosskreutz was not pointing the gun at him before he fired. So this is what I'm saying. There are so many things that may be in the jury's mind, including the way that the prosecution stated that, Kyle, why did you shoot Grosskreutz? Because he had a gun, and you felt threatened because he had a gun. And he's like, yes. And he's like, but you had just shot 2 people. Maybe don't you think that he felt threatened from you? Weren't you the threat? You had just shot and killed 2 people. You were the threat. And if that is in the jury's mind, so the Rosenbaum is not the only part where the jury could say, okay, yeah, he shouldn't have shot him. That the Grosskreutz is also somebody that the jury could say, wait a minute, it makes sense. He had just shot two people. They're approaching him like he's the bad guy. They're threatened by him. Grosskreutz is threatened by him. And if that sticks, but of course it would have to stick with all 12 members of the jury, but if that sticks, the jury can return with a much different verdict than a lot of people are expecting. So what's the lesson that we take out of all of this? Well, one, never bring a plastic bag to a gunfight. And two, don't allow the media to manipulate your emotions. We have brains. We need to make sure we use them. Thank you for checking out the channel. As always, don't forget to give me the thumbs up, like, share, and subscribe if you haven't already. Or if you disagree with me and you think, oh no, there's no gray area, Kyle's not guilty, go ahead and give me a thumbs down, but state why in the comment section that you decided to pay attention to none of the facts of the case, none of his testimony, and none of what the law actually states in the comment section. I'll see you next time.